Namaskar. In this episode of Dil Se, we're going to talk about an issue that concerns the entire nation, especially in the context of those who are being prosecuted, whether based on genuine evidence or cooked up evidence. And we've had recent judgments of the Supreme Court which are seeking to send the message to the entire judiciary that bail is a matter of right, and bail should be granted in most matters in accordance with law laid down by the Supreme Court in Gurbakh Singh Sibia's case. Unfortunately, that message, despite the fact that the Supreme Court has given that message to the entire judiciary, the trial courts and the high courts are in fact not granting bail. The result is that those who are prosecuted are languishing in jail sometimes for years before the matter reaches Supreme Court, because there are procedural issues that are involved. And if a person gets bail after 3 years, 4 years, 5 years, in some cases after 8 years, then the process becomes the punishment. And how is it that the law is laid down in cases where the individuals which go to the Supreme Court are important individuals? Some are high net worth individuals, some are politically important individuals, and that's where the law is laid down. But there are people who are languishing in jail for years. And in fact, that's 75.8% of all prisoners in this country are under trials. And the occupancy rate in prison is 131.4%. Most of them are poor people, marginalized people, people who don't know the law, people who can't get access to judges, to courts, people who can't hire advocates. That's the situation in our country, and they're not heard. So we're going to discuss multifarious issues, and we're also going to discuss the agencies, namely the CBI, the ED, and other agencies, and in the context of different laws, special laws, ordinary laws, IPC, the procedure under the CRPC, why bail is not being granted. All these issues we're going to discuss, and we have 3 exceptional people with us who are going to, throw some light on these issues. We have, first of all, Mukta Gupta ji. Mukta Gupta ji is a judge, has been a judge of the High Court from of Delhi from 2009 to 2023. She was first appointed in 2009. She's got enormous experience on the criminal side. In fact, she was the counsel for some of the most important cases being dealt with by courts. And she was a public prosecutor for the NCT of Delhi on the criminal side. And she handled the Red Fort matter, she handled the parliamentary attack matter, she handled, Nitish Katara's matter, Naina Sahni's matter, Jessica Lal's matter, and she got conviction in all those matters. Of course, I didn't know that she has a background in zoology. She got graduation in life sciences. And so thank you very much for being here, Muktaji. And we have Huzefa Ahmadi, of course. Who doesn't know Huzefa? Grandfather was a judge, father was the Chief Justice of India. And I don't think you want to be a judge. You're doing so well. He's doing so well in the profession. And he's been a senior advocate for many, many years. In 2012, I think, he's been a senior advocate. He's handling, again, very sensitive cases and multifarious areas of the law. He's nowadays handling the Gyanvapi case and many such cases. He worked with the Additional Solicitor General. You were in the chamber of Chandrasekhar, I believe.
Yes.
So thank you very much for being here, because he's a practitioner. Now, of course, Muktaji, you're also a practitioner practicing in the Supreme Court. Then we have Vrinda. Vrinda, of course, has a great background in the sense that she has been a human rights activist. And in the year 2013, she was named as one of the 100 most powerful people in the world. That's what. In Time magazine, it's not some ordinary magazine. And she's contributed to a lot of enactments in the law, like the Protection of Women from Domestic Violence Act. You have been contributing in the drafting of these laws. The POCSO, you've contributed in that, and sexual harassment of women in the workplace. also the Criminal Law Amendment of 2013, and you have a nuanced understanding of issues which are exceptionally sensitive, like HIV. You've worked in those areas, and you've appeared in a lot of important cases, especially in the context of the Sikh riots and torture issues. And you are also associated with Amnesty International and Human Rights Watch and many organizations. So we have three excellent contributors here. So let me start with you, Muktaji. Why is it that courts don't grant bail and people have to wait for years to go to Supreme Court and get it?
The law from the Supreme Court is very clear. Firstly, the triple test. Secondly, the power to arrest is one thing, but the necessity to arrest is another aspect by the police. And Supreme Court, right from Joginder Singh's judgment, has emphasized that even if you have the power to arrest, the investigating agency has to show the necessity of arrest.
Right.
Now, Section 41 also incorporates it. The dilemma comes in 41(1)(2), where in subsection B, we have the 4 parameters. Tempering, may arrest if it is likely to temper, the accused is likely to tamper with evidence, or not cooperate. But the issue is the seriousness of the offense, if the investigation so warrants. Now, that is somewhere one has to sift the material available, where you can have opinions on both sides. Whether the material for investigation is such that the accused is required for further investigation to join by custodial investigation, and if he is not taken into custody, probably the investigating material may not come. So it's interplay of that material which is required to be investigated, which often keeps the hands of the trial court judges and the high court judges tight while granting bail. Because at that stage, one of the very important grounds which is taken, or a very common ground which is taken by the agencies, this appears to be the volume of offense, and we've been able to get A, B, C evidence, and evidence so much has to be unearthed. Now, for any court to give a finding at that stage that no, he is no more required for investigation, becomes slightly critical. And then, see, when you are at the stage of trial court, it's too early to come to the conclusion. That is why when we reach high court, many people get bail, but unfortunately still many have to approach the Supreme Court.
No, but I think what you've said will be understood by lawyers, but I want this to be understood by ordinary people. I want to ask you a very simple question. In order to investigate a matter, why do you need custodial interrogation?
That's exactly what the question every judge should ask while deciding a bail application. Whether that investigation can be carried out even without the arrest. And mind you, most of the investigations which are documentary in nature can be carried out without arresting, because these are bank statements which have the money trails which have gone, for which no custodial investigation is required. Only if there is a magnitude of this kind that it's probably spread in various states or cross-country.
Why should you have custody of the individual to investigate? In fact, the law should be you investigate the offense, find material against the person, arrest him.
You don't know. You are right. If you remember, earlier CBI never used to arrest. Exactly. They would file the charge sheet and put up the matter to the court.
Exactly. Why should you?
Whereas the local police would start the investigation with arrest.
Custody means threatening. Custody means telling you,
I will arrest your wife,
I will arrest your son, I will start a case against somebody else, unless you do this, unless you do this, unless you name this. Custody is a means to implicate others. This is what custody is in this country.
So there is an element of custodial compulsive
How is that
testimony over
consistent with Article 21?
It is not. It does not.
What do you,
And that is why it is at times very difficult to even believe those disclosure statements which
exactly.
are recorded
And you
over
rely
there.
upon them to deny bail.
And what happens is subsequently, even if you don't get, you make one of the witnesses as an approver and take whatever statement you get.
Exactly.
That's another threat which is becoming very common.
Josefa, what do you say? I've raised some fundamental questions which I want you to think about.
So, the Supreme Court's repeatedly said bail, not jail. But if you speak to most experienced trial court lawyers, people who are practicing regularly in the trial court, they will say that in practical terms, the rule has been reversed.
वो तो हमें मालूम है.
And at the trial court level, it is jail, not bail. Now, you raised a very, very important point about investigation and the need for arrest. And in our country, more often than not, you arrest first without
And
any...
you investigate later.
Without any investigation
Exactly.
whatsoever, and you investigate much later.
Exactly.
And then it is you are using arrest as a tool of investigation,
Exactly.
which is essentially a legacy of a pre-colonial era. And in most countries where even after the period of colonization is over and the British have
Because
actually
there is no
left.
other country, Josefa, which has this.
Precisely. So therefore there is no other country which has continued with those pre-colonial era laws.
Exactly.
So effectively what you are doing is you are first arresting, using arrest as a tool of your investigation, and then thereafter putting a person in the frame, in a manner of speaking. The one aspect that I would like to raise is the provisions of Article 22(1), which require that when you arrest someone, you must provide him with the grounds of such arrest. Now, the expression grounds is very significant because it doesn't mean that you only provide a particular information that I'm arresting you under this section or for this offense. Grounds mean that you must have a reasonable basis for making a particular arrest. And that would imply that you already investigated before that. So I think what Muktaji was also alluding to, and what even you were alluding to earlier, that 2022(1) probably gives an indicator that ordinarily an arrest cannot be made at a pre-investigation stage at all.
No, the Code of Criminal Procedure कहता है कि पुलिस जो अफसर है उसको हक है इन्वेस्टिगेट करने का, ठीक है. और जब वो समझ जाए कि भाई, अरनेश कुमार भी यही कहता है, हमारा सुप्रीम कोर्ट का जजमेंट, तो पता चल जाए कि भाई इसको अरेस्ट जरूरी है क्योंकि मेरे पास एविडेंस है कि इसने ये कत्ल किया है या इसने कोई क्रिमिनल ऑफेंस किया है, तो उस समय वो उसको गिरफ्तार कर लेता है. लेकिन हमारे देश में गिरफ्तारी पहले होती है और इन्वेस्टिगेशन बाद में होती है. वृंदा जी, आप बताइए.
नहीं, बिल्कुल, you're right. Though I would say, while the Supreme Court has said bail is the norm, jail is an exception, but this has not been constant and consistent. Nowadays, we are hearing more of it, but again, I would say when the Supreme Court is saying it even now, it is not going to the heart of the special laws and saying it, which are putting conditions that, only if you can show, have a reasonable...
Special law के बाद में बात करेंगे, पहले बात करो कोड की.
So what is the court actually, on the point of investigation? You're absolutely right. The investigation in this country continues, and that is a colonial context. The investigation is to extract information from the person you have arrested, who's actually just a suspect at that stage. There is the investigation today, as was just said, actually can be from beyond him and outside him. Perhaps one reason which is taken into account is the heinousness of the offense, likelihood of committing the crime again, or flight risk. Again, for flight risk, you can have many other ways of ensuring that you don't have to put the person behind bars. Whether the courts are actually giving bail even today, even in the Supreme Court, placing personal liberty at the core of it, or is it that, it's taking too long? And then this is really a mysterious algorithm. What is too long? Is it 4 years? Is it 9 years? We don't know. And that messaging to the trial courts and to the high courts is confusing. We've also seen the Supreme Court, and this was unprecedented earlier, grant a stay on bail, stay on acquittal. What is the signaling then that goes down to the courts which are bound by precedents of the Supreme Court? And I would just like to very quickly add, because you mentioned that we are talking about people who are, high profile. What about others? Let's look at places like Chhattisgarh and other areas where people are languishing and they will not come out under serving half a sentence, etc., because they are usually under UAPA, attempt to murder. These are cases in conflict areas, and no bail is then granted. There was a Butch committee set up. That committee said, grant bail. These are Adivasis. They are suffering with malnutrition. The courts have not granted bail. So you are actually dealing also with the class marginalization issue here.
Actually, हमने जो सवाल उठाया था उसका जवाब अभी तक हमें नहीं मिला. सवाल ये है कि why is it necessary at all to keep a person in custody, then tell the court के अभी तो जी हमने तफ्तीश करनी है, इसने कई बातें ऐसी बताई हैं जिसके बारे में हमें लीड मिली है, उस आदमी को हमने इन्वेस्टिगेशन करना है, उसको जाके उससे बातचीत करनी है, इसको कैसे रिहा करेंगे, वो उसको कह देगा, चला जाएगा कहीं. So therefore all these things happen. Therefore courts can't grant bail. In other words, the process is such that bail is refused and the court has no way to deal with it. Therefore, what is required is a change of the structure of the law.
Yes.
Right? As the Home Minister said, we have brought in new laws in this country. We've gotten rid of the colonial past. But it is a perpetuation of the colonial past.
And actually that staggering of the police remand is likely to delay the grant of bail at least to a minimum of 40 days or 60 days depending on the offense.
When you say investigation should be over in 60 or 90 days, ka matlab investigation in order to arrest the accused. Not arrest the accused and then investigate in 60 to 90 days. This is the issue. This is the fundamental issue according to me.
That's exactly what example I gave. If you see earlier, CBI would never arrest an accused. They would take their own time to complete the investigation and file the charge sheet, inform the accused he would be present over there. Whereas the local police would always start the investigation in most of the cases with the arrest and the disclosure statement. That was the difference. But today you find invariably every investigation starts with arrest.
Correct.
There is the material before that is only the FIR or for that matter of ECR or probably statement of one or two witnesses.
There the other problem है. आपने FIR की बात की. अब Supreme Court कहती है कि you read the FIR, you accept the FIR, accept whatever is stated is true, right? And then only you can challenge it. So if somebody goes to a police station, makes an allegation which is entirely untrue, on the basis of that allegation, the person is arrested. The man doesn't know why he's being arrested because there's no evidence, there are no grounds of arrest given to him. He can't challenge it. He can't challenge the FIR because Supreme Court says you accept the FIR as it is.
Yeah,
and once you read the FIR, no offense is made out, then only you can quash it.
At the stage
So
of 482.
the result is that the process and the law is so anti-liberty, according to me, that it's impossible for the trial court to grant bail, despite what the Supreme Court says. So what's the solution to this?
See, sir, there is an amendment which has been brought which says if an FIR is to be directed by the magistrate, they will take a police report.
Yes.
Police report. I think, but then that amendment does not in 175 BNSS, but does not say to what extent you will be able to hear. What is the order which the magistrate would pass? If this kind of provision is also added somewhere in the new provision under 173 BNSS, which provides for registration of FIR, that okay, you register FIR, but before you proceed, at least listen to his part. First of all, you must be satisfied that the complainant's version is true. Most of the time, the complainant's version is not true. They do not even check whether what is stated by the complainant is true. So that's the first responsibility. If you in investigation, after you're satisfied, then you asked the probable version of the accused. It's only then you find that it is necessary that his arrest is required for that investigation to find out where lies the truth or where lies the evidence. This should be done. I think if a similar provision comes under 173 BNSS, it will help. Though it says that a preliminary inquiry should be conducted to find out a prima facie case. Now, that is in the teeth of Lalita Kumari, but it is eventually prima facie case finding means they will have to find out whether the substance of the allegation is truth.
Initially, before arresting a person, the police must investigate whether there is any truth in the allegation. Correct?
Right.
Now the problem arises. Let's assume that is the law. Now let's take this conversation a little further. That becomes the law. Now, what the police normally does, it goes to one person, takes his oral statement. ठीक है? अगर किसी को बचाना हो, तो oral statement लेंगे कि साहब इसका तो कोई दोष ही नहीं है. किसी को फंसाना हो, तो oral statement लेंगे कि हाँ तो साहब ये तो वहाँ मौजूद था. That's the problem in the case.
That's the pitfall in the.
That's the pitfall, correct? So therefore, the next question, how do you arrest a person on the basis of oral statements? क्योंकि today,
Correct.
in most cases, bail नहीं मिलती क्योंकि इस शख्स ने ये कहा, इसने ये कहा, इसके बारे में ये कहा, और ये all these political arrests that have taken place is based on oral statements. Now, question is, are oral statements sufficient for the purposes of arresting a person unless they are corroborated by some form of substantial evidence? What do you say?
So there again we go back to the first question, that is completion of investigation. So recording of oral statements or recording of statements is through the process of investigation where you are collecting material. But ultimately, unless you weigh that material,
Correct.
and when you come to a stage when you finally decided whom you want to charge or against whom you want to file a charge sheet, there should really be no arrest.
Correct.
You can call people over to police stations, detain them for limited periods. At that point of time, there can be a certain kind of regulation, not with regard to arrest or
detain
anything.
them for a particular period.
No, detain them meaning for a couple of hours.
No, why
when
you can
no, when you
investigate
call,
a person without detaining.
I only mean
Means for interrogation,
only for the
perhaps, to
purpose of-
question.
No, you can interrogate a person
Yes,
even
without-
without detaining.
no, without detaining in the sense, I didn't mean detaining in
Okay.
that sense, that you detain them for, call them for investigation. And you carry out that kind of an investigation, but unless you complete the investigation and you're in a position to weigh all the material, I don't think that any arrest should take place.
Okay, now let's take this further. Let's assume now he investigates the matter, takes oral statements, takes corroborative evidence. Then he finds that there is some element of truth in it. Then he arrests the person. At that stage, the grounds of arrest at the time of arrest must be given.
Yes.
Right.
And they'll be
Then-
substantive.
Correct. What do you say, Brinda? on that?
And
Is
they-
that procedure fair?
That would be substantive.
Okay.
And as you said, these oral statements, a 161 statement, in any case, it has a very limited purpose in a trial. Most of them come to court and say, I never said this.
Yes.
And cases collapse. Cases in which people are facing murder charges, life imprisonment. What is also the integrity of that investigation process?
Yes.
See, there's a big question mark on that in the country, and that's probably also why we are all getting a little bewildered by what is happening. So yes, there are grounds of arrest. Those will be substantive if a lot of investigation is already over. But the question that you originally asked would still remain. Does he have to be behind bars while the trial is happening?
That's the second question.
Yes.
The first question is this procedure reasonable? कि आप, if somebody has filed a complaint, find out whether that complaint has some element of truth. If it has some element of truth, ask the accused, the prospective accused, उससे पूछ लो. Wait. If it's oral statement, seek corroborative evidence. If you come to the conclusion that he should be arrested, arrest him. Correct? Now the question arises, even if there are grounds of arrest, the second question, is it necessary to arrest?
Right, right.
Because it may all be documentary evidence.
Yeah.
ठीक है ना?
Even at that stage,
Yes.
you have to see the severity of offense as also whether his arrest is necessary for the investigation.
Correct.
That is very important.
Yeah.
And coming to that first part again, FIR must be registered on that statement.
Yes.
But you must investigate to find out whether there is some truth before proceeding towards the accused. So there must be some element of investigation qua the complaint of the complainant.
Right. And at the time of arrest, give him the grounds of arrest, so he can challenge.
So then that can be the grounds of arrest.
Jैसे under the Prevention of Corruption Act, especially in the context of assets disproportionate to your known sources of income, वहाँ the procedure we all know is that you get a check period. Okay, I was a minister from 2011 to 2016. During this check period, ये मेरी income थी, ये मेरी संपत्ति हुई, और उससे पूछा जाता है कि ये तेरी संपत्ति कैसे हुई? And if he is not able to explain, then he is proceeded against.
Because one of the grounds for that is if he is not able to give a reasonable explanation.
So that principle, which is incorporated in the Prevention of Corruption Act, should be in every prosecution. What do you say?
Absolutely. So that you see the suspect, and I don't call him an accused because I don't think he should be called an accused till such time that you decide
arrested.
to lodge a charge sheet or he's arrested. But the suspect should get an opportunity to have its say before the investigating officer. And it is after weighing his say that you come to the conclusion that as to whether an arrest is needed or an arrest is not needed. So first you have to come to the conclusion as to whether there is a prima facie case against it. And then the second conclusion that you have to reach is as to whether an arrest is required or not required. So some kind of a check and balance should be followed, because today, as we said earlier, that in practice, the police first arrests and then starts investigation, which is, a complete hangover of the colonial, pre-colonial.
So, Vrinda, do you agree that we need a structural change?
Absolutely. It has to be systemic, both legally and procedurally. And the part about the version that the accused is giving. Now, that material invariably never becomes part of the record. I may actually give documentary evidence to show I am present in some other place. You are told it's a plea of alibi, bring it in defense evidence. Till then you can be behind bars.
Right.
So why does that element not enter the investigative process?
Now, we talked about ordinary laws, Code of Criminal Procedure, IPC offenses. Let's move on to special laws. You have the UAPA, you have the PMLA, right? Now, in these special laws, the provisions are completely draconian. Matlab ke under PMLA, you can arrest a person only on the basis that on the basis of the material that you have, he is guilty of the offense. That's what the provision says. So if he is guilty of the offense, how will he ever get bail?
PMLA, ECIR is based on a predicate offense.
Correct.
So there has to be some element of investigation in the predicate offense. Most often you would find that immediately on the next day ECIR is registered.
Correct.
Yes.
So there is no investigation in the main predicate offense, so that there is some material with them beyond the FIR of the predicate offense to come to that conclusion that there are some proceeds of the crime, or the proceeds of the crime have been siphoned off, or there are money trail which has to be found out. And in such a situation, how does the investigating agency come to the conclusion that he is guilty of an offense, and to disprove that it is a uphill task for the accused?
No, I don't even know why I'm arrested. How will I prove it? If I don't, nobody serves me with those grounds of arrest. Now, of course, the law is a bit changed because of recent Supreme Court judgment. But prior to that, before Pankaj Bansal, right, I was not told.
ECIR was not permitted to
तो
be.
मुझे मालूम नहीं कि मुझे क्यों अरेस्ट किया PMLA में. Yet I am supposed to be guilty of the offense. मैं रिमांड में जाता हूँ, मुझे मालूम नहीं कि क्यों मेरा रिमांड ले रहे हैं. I know nothing and I can't defend myself, and yet I am in jail and languishing for months. So what kind of laws are these? And why should the Supreme Court not strike down such laws? This is completely anti-rule of law. It's violative of Article 21. ये कैसे सुधार होगा इसका? ये तो रोज के रोज ही हो रहा है. PMLA में रोज के रोज लोग अरेस्ट हो रहे हैं.
So I feel that all these laws are manifestly arbitrary on the face of it.
Yes.
For two reasons. One is, ordinarily you hear, and there are earlier judgments or dicta laid down by the Supreme Court where they say, the more heinous the crime, the more careful you have to be
Of course,
before you
of course.
convict.
Correct.
And you have to weigh, and you have to you have to see to it that the nature of the evidence is so very strong that, and you have to be safe before you convict. Now here is a case where the more heinous laws have even more heinous provisions.
Correct.
And you are virtually, an accused is virtually non-suited. The presumption of innocence is thrown to the winds. And he is actually presumed guilty before even he faces a trial or even before the trial begins.
Yes.
So there is a very, very serious challenge which can be mounted with regard to these laws being manifestly arbitrary, UAPA, or if you see PMLA and all these laws. And like you said, that so far as predicate offences are concerned, I think, you see, the state is virtually putting each and every ostensible violation, even under the IPC, and using this virtually like a laundry bag.
But I tell you two things that have happened on this predicate offence. So, Muktaji, you mentioned about without investigation in the ECIR, how do you arrest him under PMLA? Fact is that they changed the definition under Section 3. And now the proceeds of crime are also supposed to be money laundering.
Yes.
They've changed the definition.
Yes.
They've changed the definition through an explanation, which has been upheld by Supreme Court. Result is now, proceeds of crime are money laundering. Therefore, what they do is, I'm sorry to say what they, I mean they in inverted commas, किसी स्टेट में जाना हो तो वहाँ एक predicate offense 420 का offense डाल देते हैं, तुरंत ECIR कर देते हैं, and then the ED enters that state, and ED starts investigating. So the result is,
there is no investigation in the predicate.
Exactly.
The investigation is in this.
By the ED, and that's because they've changed the definition.
And actually, charge sheets are not getting filed in the predicate offences because the
Many a time they are
entire
not.
effort is on the PMLA case.
Because you can pick up people, you can,
Yes.
again on oral statements, you can pick up people.
No, but it's also interesting, this whole thing has been brought about using this international FATF concerns.
Yes.
And riding on that, the nation is supposed to be gaining from this. I think both in terms of making corruption, of course, it's a public menace.
Somebody is certainly gaining. I don't know about the next.
It is a public menace, as is crime. And using these two, the state is actually, weaponized the law completely here. Both of PMLA and other laws which are taking away your personal liberty.
No, they are destabilizing states in this country.
That's true.
If you start moving against chief ministers and ministers and keep them 2 to 3 years, what happens to the administration of the state? And ultimately, the trial will come to nothing because it will take 15 years. In other words, the process will become the punishment. This is what they did in Hemant Soren's case. Ultimately, the High Court, on merits granted, saying that all this is, But the question is, you have used these special laws to destabilize governments, to threaten people, right? And you say this is consistent with Article 21. And Supreme Court has upheld all that.
Yes.
So what do we do about that? And the same thing with UAP. हमारे बच्चे जो हैं, Umar Khalid has been in since September 2020, where in 2024 he's in jail.
And it's their own case, no act of violence.
No. Case is he gave a speech in Bombay.
Amravati.
Amravati, and 2 days later, some events took place in Delhi, so he is the conspirator. This is the case.
So the court will have
and oral statement, then oral statements.
Yes, and protected witnesses. The court will have to be cognizant of what is happening. Otherwise, the court is also playing ostrich in a sense by not seeing what is being done with these laws. The clash, and therefore, when you say bail is the norm, it doesn't ring true for the other courts because they are not seeing them create a jurisprudence which challenges provisions of PMLA which say this.
Well, ये तो Supreme Court ही कर सकता है, और तो कोई कर नहीं सकता. So really, now the responsibility lies with the Supreme Court to set at right the kind of injustice that is being done to the polity of this country.
So there are 2 or 3 kind of cases where Like one is these so-called political cases. I mean, we have the example of Mr. Chidambaram.
I know.
You know, someone who's had, at least in my opinion, an outstanding career in public life. And it is apparent to anyone with even an ounce of common sense. I assume that those who dealt with his cases, even on the judicial side, had that. From day one, you could make out that he was put in the frame.
Of course.
And then in those cases, there is a standard operating procedure which is followed. That you first book in one case, then thereafter you see that he is at the stage of getting bail in that case. So you foist another case on him. Sometimes the arrest is made almost on the cusp of him being released on bail in another case. And ultimately, if you see, the taste of the pudding is in the eating, in the sense that after the grant of bail, how sincere has the investigating agency in both those cases been? With what sincerity have they been actually prosecuting the trials?
They're not interested.
You will find that they are not interested because they've achieved what they want.
That's right.
Because they also know that the process itself is a punishment, and they have achieved in keeping him in jail for a particular period of time, and the object has been achieved.
We have sent letters rogatory. We have sent them outside the country. He has properties outside the country. Now, this has happened after he's granted bail. There is nothing.
There is nothing.
Nothing happens. So therefore, actually, laws have become the instruments of oppression.
Yes.
Right? And if laws become instruments of oppression, what happens to the rule of law and democracy?
So when people go back to the same, even to the Supreme Court, and say this was a case of malicious prosecution, as there have been in some cases, and it is crystal clear to the court, we don't see any reparative justice being given or any accountability being affixed. Why would the system self-reflect and self-correct if the court is not going to nudge them towards it?
Oh, absolutely. Actually, ultimately, the responsibility is with the court. And if you allow laws to be misused like this and you destabilize the federal structure of this country, where will it take us as a democracy? And see what happened. Justice Bhuiyan has mentioned this. That look, he got bail in PMLA, and then the CBI suddenly after 2 years said, no, now we need to arrest him. This is obvious to anybody. You can arrest a person, but suddenly you wake up after 2 years. It is so ex facie clear that this was motivated.
So like I said, anyone with an ounce of common sense will realize that this is a case where someone is just being put in the frame. But somehow on the ground, that doesn't percolate, and somehow those persons continue to languish.
But on the ground, let's go to the next issue. On the ground, Muktaji, why does it not percolate? Why is it that trial court feel, bound, their hands and feet are bound in refusing bail? Is it a structural issue? Or is it some other issue?
As I started with, more than the structural issue, when the matter is before the trial court, it's too early a stage for the trial court to comment either. So by passage of time, when the matter comes to the High Court or Supreme Court, the courts have material to realize that actually there was nothing which they did after arrest.
But if some brave judges have granted bail, they are transferred. Isn't that true? No, I'm just asking you the matter.
That may be routine transfer also.
Oh, I see. Maybe. But how is it that all the judges who have given these wonderful judgments, even in the trial court, are routinely transferred?
That's something which I cannot comment, because it's at times routine also, that most of the time it is a routine transfer also, and it happens that
he happens to be liberal.
But I think it creates a legal culture. It creates a culture within courts that if at all bail is to be granted, a very liberal regime of granting bail, particularly in quote-unquote sensitive matters. We were naming Umar Khalid a while back. The allegation against him is of making a speech.
That's right.
Not of picking up even a stone.
No, nobody said that. No, about those children in the Delhi riots.
Right.
All those people who are still languishing in jail, some girls, some boys.
Because there is a larger conspiracy case that is created.
Exactly.
Now, conspiracies, as we know, can be spun. Now, by the time that, and it actually goes back to the same issue of What is happening to the trial in the conspiracy case?
Yes, nothing is
What
happening.
is happening to the trial in the Bhima Koregaon case?
Yes.
Between conspiracies and supplementary charge sheets, you can actually implicate people endlessly, and courts, no trials begin.
That's right.
Because the evidence runs into volumes, and actually we should read some of those charge sheets because they sound like narratives. There is no evidence listed out. And that kind of legal scrutiny has to be done by the court. How can cognizance be taken of a charge sheet that is just spinning a story and saying what the politics should or shouldn't be? That's not evidence.
This is the problem.
See, along with the statement of facts which should be forming the part of charge sheet, there are actually at times opinions which are
Yes.
circulating.
Yes, yes.
And the court has to be very sensitive enough and diligent enough to actually sift those opinions out of the statement of fact.
But I would venture to say this was not happening earlier. Charge sheets would never contain opinions in this form. Even when you had, the Indira Gandhi assassination case and others, there was evidence.
It has to be the statement of fact and a relevant fact. That is what used to happen. And that is what must happen. And then second thing, if there is a material collected by the investigating agency, at the stage of arguments in bail, the prosecution should not be permitted to supplement with that additional material which does not exist on the investigating side.
Two issues. One, you're right, that they cannot be allowed to supplement. Two, if there is material with them, which in fact is in favor of the accused, that material must be given to the accused. In other words, all documents, all investigation, जो भी तफ्तीश होती है, वो आरोपी को देनी चाहिए, ताकि he can sort of argue on the bail and on the evidence that's available. वो नहीं देते.
The law as it was that a charge sheet has to put up every material,
Correct.
whether in favor or against the accused,
Yes.
and the court has to take a call thereon. And then it started only the material which was
Relied
in favor
on.
of the prosecution was relied upon.
Correct.
Now, Justice Lalit, in that judgment in suo motu action, which was on the recommendations of the various high courts, said, no, the entire material, you will give a list at that stage and you will permit an inspection if sought for. Now, again,
They resisted. They
yes,
resisted.
yes. But then that has really helped now today if at that stage once 207 takes place, the documents are supplied, the parties go and ask where is that material. After all, you in one go have seized away 10,000 documents. The person won't know there must be 10 documents which are in his favor,
Correct.
which may disprove the court. Unless that person accused or suspect has the investigation, he can't just bill up the case.
I'll give you an example. In Delhi riot case, the Delhi police videographed everything.
Oh, yes.
Right? Now, they are not releasing that video to the accused. That video will show that all the allegations that they are made are false.
Correct.
Right? But they are not giving it. And people have filed application after
Yes.
application. What do you do about this? And the Supreme Court must come down and say everything should be done. So ultimately, this responsibility is with the highest court of the country.
Absolutely.
What do you say?
Yes, absolutely. And ultimately, what is the object of a prosecution? I mean, that is something which, that's the question that we have to ask. Is it merely securing a conviction? Or is it to ensure that justice is done? And for the purposes of ensuring that justice is done, it's necessary that you must share all the material fairly, even that material which goes against you. In fact, you must be cooperative even towards the defense, and all the material that they ask must be given, because you must give the impression that you have nothing to hide.
Absolutely.
And over here, on the contrary, at each and every stage, the attempt is to hide each and everything from what the defense is seeking.
What happens is that the prosecutor comes to court and says, "Ki Sahab, we want to frame a charge." They are delaying the trial because they are keeping asking for documents under 207. They don't want us to frame the charge. And the accused is saying, no, but you give me those documents before you frame the charge, because I'll argue that I should not be charged.
That's right.
So this goes on for years.
So this is what I was referring in the Bhima Koregaon case. They have taken devices. and they claim that there is some material in the devices, they have to give cloned copies. From 2018, this investigation began. We are now in 2024. And the charge is not getting framed because they don't give the copies. So what is the burden on the prosecution, on the investigation, and who will ensure that they do their job? Then after 4 or 5 years, people are then let out on bail. But I think the purpose of putting the chilling effect on anybody who disagrees has actually already been served. And of course, as you said, political instability is created.
I've got some data here which I just want to share with the public and with you. You know, what kind of people have been arrested? 65% of under trial inmates have not completed class 10. 65%. Most of the people are uneducated.
So the poorer sections.
Poorer sections, and they are languishing. They will not get bail. Tabhi to maine kaha na ki when high net worth people move the Supreme Court, then the law is settled. Then they are interesting, and you know, at this point, there are about I got only 2022 figures, caste-wise. SCs are 90,951. STs are 40,221. OBCs are 1,50,684. And others are 1,14,383. This is the kind of figures that we have. Most of them belong to that category. And they will never get paid.
And I'm sure if you look
and
at
region
Basically, it comes to that poor people and marginalized section.
Exactly.
Yeah.
I mean, the denotified tribes, for instance, their percentage would be very high of those who are then put away under all manner of laws.
Exactly. And 3 in 4 person inmates are under trials.
Yeah.
What do you do with this kind of thing? And as far as the duration of trial is concerned, let me tell you some figures there also. Up to 3 months is 1,39,000. Up to 3 to 6 months is 85,000. 6 to 12 months is 74,000. 1 to 2 years is 63,000. 3 to 5 years is 25,000. And above 5 years is 11,000. These are the people who are just there. And most of them will be these marginalized communities.
So when you said what is the systemic shift?
Yes.
The systemic shift in the conversation we're having, one is the necessity to arrest becomes the central argument.
Case against Akhil Gogoi.
Yes.
Yes.
I represented
In
him.
Assam.
Yes.
And
He was discharged.
Yeah, he was discharged, and then again he was again sought to be put in the frame. The discharge order was set aside by the High Court.
No, but he was ultimately acquitted in 2021. In July 2021, he was acquitted of all charges by a special NIA court.
No, that has been reversed. That has been reversed by the High Court. He's facing trial, but fortunately he's on bail.
Right.
So therefore,
High Court has reversed.
High Court reversed it.
Oh, I see.
And then thereafter he's again been.
Well, at least he's out at the moment.
He's out at the moment. The Supreme Court granted him bail and said that notwithstanding your restoring the charge sheet, you will now not again take him into custody.
So all we can say is, God forbid, the police in this country arrests without investigation. And God forbid that, that they have an eye on you. The other real problem, according to me, and I say it quite openly and I've said it publicly also, why have investigating agencies become, what should I say, the long arms of the state? They have.
Well, to some extent they always were, but perhaps the so-called special laws and their stringent powers and draconian powers have actually now enabled greater incarceration and greater politicization.
Which means that the politicization of the investigating agencies is in fact one of the most dangerous things that have happened in the last 10 years or so.
You should speak to people when they are interrogated at the special cell. It makes for fascinating hearing because nobody is asking you about the crime. They're asking you about your thoughts and your ideas and your politics.
So this is perhaps, according to me, and we should end this program, that the real worry is the politicization of the investigating agencies.
So this has been even judicially recognized.
Yes.
Now on 2 occasions, the CBI has been called by the Supreme Court a cage parrot.
Correct.
Yes.
And that is a sterling indictment of what the apex court thinks about these investigating
But now
agencies.
you rely on the CBI in some cases, and you say that CBI is a cage parrot in other cases. Now how does it sort of match?
it becomes a bit of an oxymoron.
That's right, that's right. Well, that's what it is about the state of affairs in our country as far as investigation is concerned and laws are concerned. They say that we have gotten over the colonial past, the legacy of the colonial past. I say we have perpetuated it by the kind of laws that are in operation in this country. Thank you very much for being with us.
Thank you.
Thank you.
Thank you.
Thank you.